Our next case is Akron versus Irvin. Do we have everyone we're expecting here? I don't know if there's any parties going to come to watch other than the folks that are here today. And we are a little early, so if that's the case, let me know.
This is it for us, Your Honor.
This is it for us as well.
Are you ready to proceed a little bit early then? All right, thank you. Please be seated. In this case, of course, you each know that you'll have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve for rebuttal?
2 minutes, Your Honor.
All right, thank you. Note that. You can see up there the clock. Would it get down to 2 minutes left, just that top one, what you want to look? Please don't look at your rebuttal time. I won't change that from 5 minutes. You're just looking at that top clock. I will try to let you know when you have about a minute left, so you're aware of that when you're in your time. The arguments are being recorded, so when you come up, please come to the podium. Make sure to introduce yourself. Please stay behind the podium as we're recording both visually and audibly, and then I'll make sure we can see you. And if you get away from the podium, we lose you both visually and audio, so please do that. You should not use the name of any child, minor, or victim in this case. If you have a victim to refer to, in this particular matter, for instance, if you use these initials, or just a designation victim or something else, that make sure we know who that person is you're referring to without the full name being used. Having said that, we read your briefs, are ready to proceed whenever the two of you are.
Good morning, Your Honors, and may it please the Court. My name is Robert Reed, and I'm here, and I'm a certified legal intern representing the defendant appellant, Mr. Anthony Irvin, under the supervision of Andrew Paulus. I would like to reserve 2 minutes for rebuttal. Mr. Irvin is respectfully requesting that this Court reverse the trial court's decision to deny his Rule 29 motion and enter a final judgment of acquittal. This is a rather simple issue. The state failed to show that Mr. Irvin had a knowing mental state when AS's window was broken. It thus failed to meet a required element of criminal damaging under Akron City Code section 131.06, and therefore the trial court should have granted Mr. Irvin's Rule 29 motion. The state completely disregarded the burden of showing the knowingly requirement of Mr. Irvin's mental state at the time the window broke. So what was Mr. Irvin's mental state when the window was broken? It's not discernible from the evidence at trial.
Counsel, can I ask the briefs, one brief says window and the other brief says windows. What was the evidence at trial? Was there more than one window broken?
Your Honor, there was evidence of multiple broken items at the residence, but the actual charge of Mr. Irvin was one broken window of the residence.
Thank you.
There were no witnesses who knew how the window broke. There's no evidence of a threat to break the window from Mr. Irvin. There was no evidence that shows beyond a reasonable doubt that Mr. Irvin knowingly broke the window. Rather, the body camera footage reveals that police officers asked Mr. Irvin about multiple broken items on the property, including a closet door and the window that was put into the charge. When asked about the broken closet door, Mr. Irvin stated that if he had broken it, he would be willing to pay for it. However, when asked about the broken window in question, he stated not once, not twice, but 3 separate times that he knew nothing about the window breaking and was just as confused as the police officers asking the question. If Mr. Irvin had known about the broken window, then he would have responded accordingly to the police officers' questions in the same manner he did regarding the closet door. But he didn't, and his statements show that he did not have a knowing mental state about that broken window. The state also makes an inference that the broken window was foreseeable when moving large furniture through the house, an inference that is not only speculative, but legally flawed. The state inferred that Mr. Irvin created a foreseeable risk of breaking the window by moving the large furniture, but Mr. Irvin's actions were neither violent nor erratic while moving these items. The body camera footage shows only that when officers arrived at AS's residence, Mr. Irvin was calmly moving a mattress through the front door. By implying that Mr. Irvin could foreseeably see a window breaking would only be evidence of a negligent mental state, not the knowing mental state that's required for the statute in question. The state is simply trying to rewrite the Akron City Code by inferring a negligent state of mind would be enough to satisfy. Furthermore, by following that same logic of the state's inference, then anyone who moves furniture near a window that may break could be prosecuted because just the act of moving furniture near a window is what the state is attempting to criminalize in this case. The state also conflates recklessness with knowledge and once again fails to show any evidence of Mr. Irvin having a knowing mental state. On page 9 of the trial transcript.
What about circumstantial evidence? The police were there because there was a argument between a couple. Wouldn't that be an implication of his current mental state?
Respectfully, Your Honor, that would be an attenuated inference, and that does not show the mental state at the time the window was broken. The argument that the police were responding to happened roughly 2.5 hours before the police actually arrived at the scene and saw Mr. Irvin moving the mattress out of the front door.
So what about the fact that multiple items are broken? I mean, wouldn't that infer that it wasn't accidental or negligent?
It may be accidental, but that doesn't show a knowing mental state. And the negligent is not enough to meet the knowing mental state that's required under the Akron City Code here. Akron City Code section 131.06 states that recklessness is enough only when using inherently dangerous materials, like fire, explosion, poison, or other dangerous substances, none of which were mentioned in the complaint or in the none of which were mentioned in the charge for Mr. Irvin, and none of which are present in this case. So similarly to negligence, recklessness is not enough to meet the requisite mental state that's required under this statute. Even if the officers witnessed reckless behavior when they arrived at AS's house, the recklessness can be used to describe the mental state of only the actions that the officers witnessed once they arrived at the scene firsthand, not Mr. Irvin's mental state at the time that the window was broken, which occurred before the officers arrived. In conclusion, there's no possible way for the jury to find enough evidence to meet the requisite legal standard of a knowing mental state at the time the window broke beyond a reasonable doubt. Therefore, this court, we respectfully ask that it reverse the denial of Mr. Irvin's Rule 29 motion. I'd like to reserve the remainder of my time for rebuttal. Thank you.
When you're ready, counsel.
Thank you, Your Honor. Your Honors, and may it please the Court, my name is John Skaken, legal intern representing the appellee of the City of Akron, Ohio. The case before you involves a single issue, whether at trial the City of Akron presented sufficient evidence to show that Mr. Irvin knowingly caused or created a substantial risk of physical harm to the victim's window. We ask that this honorable court affirm the trial court's finding in favor of the city. At trial, the city clearly established beyond a reasonable doubt that Mr. Irvin knowingly caused or created a substantial risk of physical harm to the victim's window by presenting what Mr. Irvin said that night, what officers said, and what Mr. Irvin did. The city presented at trial that through the statements that Mr. Irvin made to officers on the night of the incident, that he knowingly caused a substantial risk of physical harm to the victim's window and established its mens rea requirement. At trial, the city was only required to show that Mr. Irvin acted knowingly, which it did. Akron Code of Ordinances, section 131.06 provides that no person shall cause or create a substantial risk of physical harm to any property of another without his consent, knowingly by any means. The code continues to define an individual's actions as having been conducted knowingly, as when an individual is aware that his acts would probably cause a certain result or were of a certain nature that might lead to a specific outcome. The city was not required to show some unequivocal foresight by Mr. Irvin that he intended to break the window. Rather, it only needed to show that the individual was aware that circumstances probably existed to establish knowledge in this case. And at trial, the city did this, and it met its basic duty to establish that Mr. Irvin was aware that his acts would probably cause damage, lead to, or cause damage to the victim's window when it presented the statements that Mr. Irvin made to police officers the night of the incident. That night, the victim and her daughter fled the victim's home after the victim returned to her home with Mr. Irvin, after Mr. Irvin had poked her in the face. All of this is established at trial by the victim's testimony, by the testimony of her daughter, by the testimony of officers Donahue, Johnson, and Kmoot, Sergeant Brewer, and the body cam footage and the photographic evidence that officers took that night. After she fled to her mother's home, the victim called Akron police to asking them to check on her home. Mr. Irvin had remained in the home. Notably, she informed officers that her home was not in a state of disarray when she left, and that the window had not been broken at the time that she left.
Counsel, where, and if it's in the record, where is this window located?
Your Honor, I believe according to the transcript that it was established at trial that the window was located on the front of the victim's home.
Near the door?
Yes, near the door.
Thank you.
And you agree from the charging document, we're only talking about one window here and no other property on the premises?
Your Honor, it's debatable whether there were one or two windows broken. However, it was according to the charging documents, only one window is at question here. Akron Police Department officers arrived at the victim's home around 5 a.m. and according to their testimony and according to their footage, they found Mr. Irvin moving a large queen-size mattress through the front door of the victim's home. Additionally, they saw multiple items of women's and children's clothing strewn about the front yard of the house, in the double strip, and near the road. Additionally, it was established at trial that there was a badly damaged laptop in the front yard, a broken dog cage, and also a closet door that had been ripped from the hinges and hurled from the home. In Trial Exhibit F, Mr. Irvin told Akron Police Department Sergeant Brewer, quote, "A window got broke. I'll pay for it." This statement...
Didn't he say if the window got broken?
Your Honor, he did say if at a different point in the same trial, in the same trial exhibit, Trial Exhibit F. This statement indicates that Mr. Irvin possessed knowledge of what had happened that night, and the second statement, "I'll pay for it," indicates Mr. Irvin's acceptance of responsibility for the broken window.
Well, if he was negligent and just accidentally hit something, would he just also feel responsible and have to pay for it? Why did that assume that was knowing somehow more than negligent behavior in this case?
Yes, Your Honor, it is possible he could have said that if he knew that it was broken. However, further statements in this trial exhibit indicate that Mr. Irvin satisfied the knowingly requirement. Specifically later on in that same exhibit, when Mr. Irvin stated to officers, quote, "I'm in the process of moving. Of course, things are going to get damaged."
So when you're saying there were women's and children's clothing and a queen-size mattress, are you trying to say that that was inconsistent with his statement? He says I'm moving?
No, Your Honor, I was just providing those details to show that that Mr. Irvin was in the process of moving large pieces of furniture, and that this...
Just moving in general, you're saying?
Correct, yes. It's setting the scene and establishing that there was a movement of large items of furniture throughout the home. This statement, especially the statement, "Of course, I'm in the process of moving," indicates that Mr. Irvin knew that moving furniture would probably cause damage. In fact, that it would, of course, cause damage. And in fact, here it was the damage to the window in front of the victim's home. The city provided evidence that Mr. Irvin took sole responsibility for breaking the victim's informing Sergeant Brewer that he possessed sufficient knowledge, repeatedly stating, "I know what I'm doing." Mr. Irvin relies on his statement stating, "If I broke the windows, I'll pay for them," to indicate that he was unaware of having broken the window or that he did not satisfy the knowingly requirement. However, if he did not know that he broke the window, he probably would not have stated, "If I broke the window." He would have simply denied having broken the window upon an inquiry by anyone, by a police officer. And also notably, nowhere in the testimony at trial did any party establish that the victim had consented to...
What I'm having, I guess, difficulty in viewing the city's approach in this case is that any time someone's moving, they accidentally damage property, they could be charged criminally. That seems to be what you're suggesting here. Tell me what limitation there is on people are moving their property, they accidentally break a window. and that is going to subject them to criminal liability. Tell me what limiting principle you're telling me exists here, so someone who's acting on moving property is in charge of criminal.
Of course, Your Honor. The fact that this case go beyond simply just moving property out of one's house. The circumstantial evidence that the city presented at trial indicate that Mr. Irvin was of a mindset that led to his destruction of the window upon moving the items out of the house.
Well, it sounds like what you're saying is he wasn't moving his own property, he was moving out somebody else's property.
That is correct, Your Honor.
I mean, who's the laptop belong to?
I believe it was established at trial that the laptop belongs to the victim.
There's a queen mattress,
Correct, Your Honor.
you're saying women's and children's clothing, so he's not just moving himself out.
Yes, Your Honor.
He is moving all her things out
Correct, Your Honor.
when she's not there.
Yes, Your Honor. And she did not consent to this either. There's no indication that she consented to that. She did not know that he was doing that. It's possible to infer from the testimony that she had suspected that that might happen. That's why she called 911 that night. Clearly calling 911 is also not indicative of one's consent to having their property moved out of their home in the middle of the night.
How does that tie into criminal damaging of a window?
Your Honor, I heard on this point to continue the line of questioning from Judge Lansinger. I think that also moving this property in the middle of the night in this manner, as I said, is circumstantial evidence of the mindset necessary to destroy the windows. Essentially, and additionally, it provides that that his actions were of a nature that might lead to a specific outcome in the breaking of the windows. And this can, the city established also that through Mr. Irvin's actions alone, that he knowingly created a substantial risk of damage to the victim's window. A defendant's mens rea can be inferred by his acts, and such inferences are circumstantial evidence which are proper in this context. It is long held from the Ohio Supreme Court that a defendant's intent can be determined from the surrounding facts and circumstances, which echoes long-held understandings from the Supreme Court, the Ohio Supreme Court, and the United States Supreme Court. I'll point out the United States, in which the Supreme Court held that every man is presumed to intend the natural and probable consequences of his own act. Here, Mr. Irvin agrees that the natural and probable consequences of moving furniture is damage when he stated that I'm in the process of moving, of course things are going to get damaged. If we apply Allen v. United States here, every man is found to intend those natural and probable consequences of his act. We can understand here that Mr. Irvin had intended the breaking of the window, since damage, as he stated, is the probable and natural consequence of moving the window. And knowingly is subsumed in intent, so here we can understand too that the knowingly requirement was satisfied. So in addition to the damaged property outside of the home, the facts presented at trial indicate that Mr. Irvin had caused severe damage to the interior of the victim's home as well, which showed from body cam footage and from photos officers took on the scene that night that the interior of her home was badly damaged. Again, I'll point to the victim's testimony where she stated that when she left her home, it was not in a state of disarray. Clearly, the substantial risk of physical harm that Mr. Irvin applied to the home's exterior and interior included the victim's window, which is accessible on the inside and outside of the home. These acts were circumstantial evidence that Mr. Irvin was aware that his acts would probably cause the broken windows, or that the nature of moving large furniture out of the victim's home and destroying its interior was of a certain nature that might lead to the destruction of the windows. Additionally, it was established at trial that Mr. Irvin had acted alone. He was the only one who remained at the victim's home when the victim left, and the only one there when police officers arrived. Furthermore, Mr. Irvin stated that he complained to officers that no one was helping him move large pieces of furniture, so Mr. Irvin and Mr. Irvin alone was responsible for this. All of the evidence that the city presented at trial is sufficient to satisfy this court's number review that upon viewing the evidence in the light most favorable to the city, that any rational trier of fact would have found that the city satisfied the elements of the crime beyond a reasonable doubt. Lastly, I will point to 2 additional points made at the final page and a half of the appellant's brief regarding admissibility of evidence. Crim Rule 29 only addresses sufficiency and not admissibility of evidence. Mr. Irvin further did not object to the admissibility of evidence at trial, so it was not preserved for appeal. He could only use plain error on appeal, and there's no such language indicated in his brief to use plain error. Additionally, alleging an admissibility issue was a violation of this court's local rule 16A7, which requires that an appellant separately discuss each assignment of error with the applicable standard of review, and Mr. Irvin did not do this in the brief. In sum, the city respectfully requests that the judgment of the trial court be affirmed, thereby establishing that under the law, an individual who threw large pieces of furniture from the victim's home without her consent and in the process led to the breaking of her window, knowingly caused or created a substantial risk of physical harm to the window that he broke. Thank you, and may it please the court.
Thank you.
You'll have your full 5 minutes for rebuttal.
Thank you, Your Honor. May it please the court. We are here to talk about a dispute that is about whether Mr. Irvin had a knowing mental state when he broke the window, not whether or not he broke the window to begin with. It may have been an accident, he may have bumped it, but that's not what we're here to discuss. The evidence presented at trial was supposed to show that Mr. Irvin had a knowing mental state, and the state failed to present evidence of that. In Exhibits D and F at the trial court, Mr. Irvin stated that if he broke the window, if he fell back into it, he'll pay for it. That does not show that he had knowledge of breaking the window to begin with. He responded to the closet door question, as I stated earlier, that if he broke it, he'd be willing to pay for it, but expressed confusion about the broken window to begin with. Furthermore, the evidence that my opponent speaks of treating the victim and the daughter, making them flee their house, the other property that was strewn across the front lawn, none of this shows that the knowing mental state that is required. It's all circumstantial evidence. If you picture a glass wall, and on the other side of the glass wall, there is all of this evidence that may portray him in the bad light of having the strewn objects on the front lawn, the alleged discussion causing the victim and her daughter to flee 2.5 hours before the police arrived. The glass wall is the knowing mental state that is required under the Akron City Code here.
But isn't circumstantial evidence to be given the same weight as direct evidence?
Circumstantial is enough in other cases, but it's not enough to show the knowing mental state here. Rather, the state could have presented evidence of a witness describing the way that Mr. Irvin was moving the furniture. They could have had some evidence that someone warned Mr. Irvin ahead of time, or there could have been some evidence from the victim herself stating that Mr. Irvin was going to break the window at her house. None of this evidence exists because there's no evidence of the knowing mental state that Mr. Irvin had at the time of moving items out of the house. What the state is attempting to prove with the circumstantial evidence is a foreseeable or negligent mental state, which is not enough to meet the requisite knowing mental state under Akron City Code. They mentioned a lot of things being broken, but the things are not the window. What we care about in this case is the knowing mental state with regard to the window being broken. We would like to further point to the analogy I stated earlier, where by following the logic of the state's inference that having a negligent or foreseeable mental state is enough to be found guilty under Akron City Code, section 131.06, then anyone who moves furniture near a window that may break that window could be prosecuted because just the act of moving furniture near the window is what the state is attempting to criminalize here. Therefore, we urge this court not to accept that and reverse the denial of Mr. Irvin's Rule 29 motion. Thank you.
Thank you. All right. I want to thank both of you for your presentations today on behalf of the court. The court will take the matter under advisement, issue a decision in due course. When that decision is reached, we mail to the parties both through the clerk of courts and also available on the High Supreme Court website. Again, thank you.